Okay, so today we are going to discuss very important topic is on bail. So it's our 11th lecture. So 11th lecture is on bail and related provisions which are there about the bail. So very important topic what we are going to discuss. So when we discuss about the provisions relating to bail, uh, we'll discuss about its meaning, classification, power, what's are there vested with the court, then bail bond, forfeiture of bond, etc. Some new trends which are there on the bail, as well as the cancellation of bail. Cancellation of bail we'll discuss at the completely at the end of the today's lecture. So we'll try to cover the almost all aspects relating to bail in today's lecture. So very important class or lecture for all of you. Let me proceed with the bail. Remember, when we discuss about the arrest, we use the word that every single arrest resulted in deprivation of right to liberty of someone. So we curtail liberty of someone when we arrest someone. Accordingly, the one of the immediate remedy which the judiciary can give or court can give is the enlargement of persons on bail. So pending all inquiry, investigations, etc., a person should be enlarged on bail unless there's a requirement of keeping them in custody. There might be some justifications, but the normal rule could be because someone's constitutional rights are violated, and in our system, accused is presumed to be innocent until proven guilty. And this system does not develop automatically in one day. It's all started from the Human Rights Instrument, ICCPR, International Covenant on Civil and Political Rights, to which India is a party and ratified. So it's a binding obligations, which explicitly says that every accused person should be presumed innocent unless proven guilty. So till the time someone is proven guilty, they have to presume as innocence. And when we are presuming them innocence, why to keep them behind the bar? So there is no justifications to keep someone who is innocent behind the bar. That's the conflicting issues that we are one side we are presuming innocent, other side we want to keep them in custody. So from there only, the court consistently says that bail is a rule, jail is a exceptions, and there are very landmark judgments where the court says that the accused should be entitled to bail. We'll look into one by one all of them. So we'll discuss about the bail. So initially we start with the statutory bail, where accused has a right to get bail, and the followed by the bail by magistrate in non-bailable offences, bail by the High Court and Session Court, the other requirement of provisions of the bail, and then at the end, cancellation of bail. That's what we're going to discuss. Now, this slide we have seen earlier. We know in the BNSS, first time they incorporated a definition of bail in section 2. In the old law CRPC, we did not find any definition of the bail, and judiciary in normal circumstances, they interpret in the same way the way this definition has been added. So bail means release of a person accused of or suspected of commission of an offense from the custody of law upon certain conditions imposed by an officer or court on execution by such person of a bond or bail bond. So the bail is order to release someone's with conditions. Sometimes conditions could be that he should meet with the IO. Sometimes condition should be he should not go out of the local jurisdiction. So there could be any multiple conditions which can be court can impose, and the release will be either on bond or bail bond. When we say bond word, is normally considered as personal bond, and bail bond with third party security. So someone is stand guarantor and submit the bond. So we will we'll discuss these provisions. So when we look at this bail, the primary object of these provisions related to bail is The object of arrest and detention of the accused person is primarily to secure his appearance. That's the ultimate objectives. So even when we don't release someone on bail, one of the considerations in the mind of the judges used to be that, okay, without bail, it will be difficult to bring or produce him before the court. Secure his appearance at the time of trial and to ensure that in case he is found guilty, he is available to receive the sentence. If his presence at the trial could be reasonably ensured, otherwise than by his arrest and detention, it would be unjust and unfair to deprive the accused of his liberty during the pendency of the criminal proceeding against him. So that's the basic rule. The judicial system required that the accused should be present to face the sentence, to receive the sentences. And if the accused presence can be ensured in the judicial system, then no point in keeping them behind the bar or behind the custody. So bail has been defined in the law lexicon as security for appearance of the accused person on giving which he is released pending trial or investigation. So in that way, this is the bail is being granted. Now, is bail as a matter of right? So some circumstances we know bail is a matter of right. So we will discuss that. So what are those circumstances? First circumstances comes when we look at the provisions relating to investigation. In the CRPC, it was 167. In the new act, it is 187. And there, while discussing about investigation, I said we will discuss about the bail provisions a little later. The bail. So let's see clause 3. What the clause 3 says? So clause 1 and clause 2 talk about the keeping the persons in custody, police during the investigation. So someone might be arrested by the police and the investigation is going on. So persons might be sent initially, might be to police custody or maybe later part also. Now the law permit there can be police custody, maybe judicial custody. But how long? So accordingly, clause 3 says, clause 3 first part, but no magistrate shall authorize the detention of the accused person in custody under this subsection for a total period exceeding 90 days where investigation relating to offence punishable with death, imprisonment for life or imprisonment term 10 years or more. 60 days where the investigation relate to any other offences. So that means if the investigation is not completed, police has not submitted police report within the period of 90 days, in cases where punishment is 10 years or more, and other cases within 60 days if the police has not submitted the police report, that means this section applies in those circumstances. So after 60 days or 90 days, magistrate cannot pass order for further custody or detention of that particular persons. And on the expiry of said period of 90 days or 60 days, as the case may be, the accused person shall be released on bail if he prepared to and does furnish bail, and every person released on bail under this subsection shall be deemed to be so released under the provision of 35 for the purpose of that chapter. So that means under this section, the accused has right to be released as a matter of right, he shall be released. If police do not submit their police report, police do not completed investigation within 90 days in cases where the punishment is 10 years or more, 60 days where punishment is, other cases where punishment is less than 10 years, etc. So in other cases. So in these cases, the accused has a right to be released on bail. This is the statutory right. Mandatory bail provisions. Accused rights are there if he able to submit bond. Remember, the court can only pass order for release, but for release, a bond need to be submitted. Someone has to stand as a grantor, as a surety. So either bond or bail bond. So we're depending on the order which passed by the court, the releasing order which the court passed. Clause 5 talk about no magistrate second class, etc. We don't have a second class magistrate in West Bengal. And the last proviso which we have discussed earlier, we are not directly concerned on the bail. So the accused basically under this section has a right to be released on bail. Old provision in CRPC it was 167. And in Matabar Parida case, Supreme Court says it is not possible to complete investigation within a period of 60 days or 90 days. They when in serious and ghastly type of crimes, the accused will be entitled to release on bail. So the police has to submit. If the police don't want that the person should be released on bail as a matter of right, then they have to submit police report within those period 90 days or 60 days. Then this section does not apply. This section applied during investigation when investigation is not completed. So accordingly, once the investigation is not completed, police has not submitted report, it is a matter of right of the accused to be released on bail after 60 days or 90 days, depending on the cases. But there might be some other circumstances. There might be a circumstances. Say, for example, after the 60 days or 90 days, accused persons file application for bail. Court granted bail or court the application is pending for hearing. In the meantime, police report is submitted. Now, in many circumstances, liberty of the accused. So, in this case, AB Desai versus State of Maharashtra, the investigation must be carried out with utmost urgency and completed within the maximum period allowed by proviso of 167(2). Which become in the new section, it is section 187. So what was 167 become 187. If it failed to show a sense of urgency in the investigation of the case and omit to default to file a charge sheet within time specified, the accused would be entitled to be released on bail. So this is statutory bail. Law permit, irrespective of going into merit of the case, court must release the persons on bail. This is the right of the accused. Prahlad Bhatti, mainly because an accused was initially granted anticipatory bail for the lesser offense that would not entitle him to be granted regular bail when he is found to be involved in the greater offense. That's a different situations where if the charge sheet is a different section. In there's another case called Ashok Munilal Jain versus Directorate of Enforcement. We know the Directorate of Enforcement functions under PMLA, Prevention of Money Laundering Act, and one of the very draconian law which we have presently. And we know how these draconian laws has been used by political power to achieve political gain in many circumstances. So here in this Ashok Munilal Jain case, Supreme Court says that section 187(2) to cases arising out of PMLA, as per provision of section 4(2) of CRPC, procedure contained therein applies in respect of special statute based on some other circumstances that is applicable to PMLA. But if the PMLA is silent, then the CRPC is applicable. Moreover, section 44 to 66 of PMLA especially incorporate provision of the CRPC to trial under PMLA, including applicability of CRPC. On the contrary, the provision of specific inclusion, even section 65 PMLA Act itself settled the controversy beyond any doubt. That means even in PMLA cases, the CRPC, now the BNSS shall be applicable. There's another case called Vikramjit Singh versus State of Punjab. Right to be default bail, Supreme Court says, is a fundamental right and is not a mere statutory right. Now I said it's the statutory right, but when the court says fundamental right, court read Article 21. So it is a part of procedure established by the law under Article 21 of the Constitution. Therefore, a fundamental right is granted to an accused person to be released on bail once the condition of first proviso to section 167(2) are fulfilled. Words if already not availed of by the Constitution bench in Sanjay Dutt means that once the right to default bail has been indefensible, upon application for default bail having been made after expiry of the maximum prescribed period, Filing of charge sheet thereafter is of no avail and does not affect the indefeasibility of the accrued right to default bill. So court was very clear that once the timeline is over, statutory right. So that's a very important thing. So suppose someone is submit applications and the person is not released, and in between the charge sheet is submitted. Now the court link this right statutory bail from the constitutional rights fundamental right. So court says right to default bail become complete and indivisible as soon as the application for grant bail, regardless of its forms, even if it's oral, is made on expiry of the maximum period before a charge sheet is filed. Thereafter, this indivisible right firstly cannot be defeated by filing of charge sheet. Secondly, it cannot be defeated whether there is a non-disposal of or wrong disposal of the application of default bill before or after filing the charge sheet. Thirdly, filing of a subsequent application for default bill will not defeat the indivisible rights already stand accrued to the accused based on the first application. Application for statutory default bail need not be writing, it can be made orally also. So court in very broad terms says that these are rights are constitutional rights, indefeasible rights. So we cannot take away these rights, we cannot compromise with these rights. These are the basic rights of every accused person and they should be enlarged on bail after this statutory period is over and the charge sheet not submitted. There is another case called M. Ravindran versus Directorate of Revenue Intelligence. And Supreme Court says the moment accused file application for bail on default of investigation agency in filing charge sheet within prescribed period and offer to furnish bail bond as directed by the court, he is deemed to have availed of his indivisible right to be released on bail. Avail of means actual release from custody by furnishing bail and complying with the terms and conditions of the bail order within the stipulated by the court. Now, there are other judgment also where the court has talked about this right. For example, bail or jail, judicial discretion to grant bail in non-bailable offences. Their criteria. So there is a Motilal and others versus State of MP, where Supreme Court laid down three propositions explaining the meaning and purpose of the provision regarding bail. Firstly, bail covers both release on one's own bond with or without surety. So when with surety we call bail bond. Secondly, fixing an excessively high amount bond, keeping in consideration the facts and circumstances of the case and economic condition of the accused, violate the constitutional norm. So you say, okay, statute right I'm giving, but I'll fix the bail amount of 20 lakh rupees. No, poor villager, from where he get 20 lakh rupees? That means indirectly you are denying the rights which are constitutional rights. Thirdly, surety need not come from the district of the court concerned. So the law laid down in Moti Ram case has been reiterated in subsequent cases like Husna Khatun versus Home Secretary. So grant of bail, reasons to be stated when there might be some circumstances where look, bail is a judicial order and every single judicial order has to be reasoned. So accordingly, we have to give reasons. Now, when is a statutory bail, the statutes, the period is itself is the reason to grant bail. So reasons for granting a bail must be stated when the offence is of serious nature. The following factors among other must be considered. A, the nature of the accusation and the severity of punishment in case of convictions and the nature of the supporting evidence. Reasonable apprehension of tampering with the witnesses or apprehension of threat to complainant. C, prima facie satisfaction of the court in support of the charge. So considering all these things, court can decide whether bail to be given or not, and whatever the decision court should take, court have to give reasons of it. In Puran versus Sekhar, court says court while granting bail should give reason. At the stage of granting bail, a detailed examination of evidence and elaborate documentation of merit of the case has not to be undertaken. That's not required. Remember, in case of statutory bail is a right, but even in the other bail, etc., uh, it's not the stage when we look into entire detailed evidences. It's all prima facie. In another case, Kalyan Chandra Sarkar versus Rajesh Ranjan. So, alias Pappu Yadav. A detailed examination of evidence and documentation of the merit of the case need not be undertaken while granting bail, but reasons for granting bail must be given if the offense is serious. So, there is a requirement of giving reasons. If the bail application has been refused earlier, then onus lies on the court to notice reasons, ground of earlier refusal, and give reasons why bail is being now granted to the accused despite earlier refusal. Now we come to, so first we give a scene, the statutory sheet, then person has a right to grant bail. Now second right to grant bail is in what cases bail to be taken. So there is a right to grant bail. In what cases? When any person other than person of non-bailable offences, if it is other than person of non-bailable offences means bailable offences. So 4th and 8 talking about bailable offences. In bailable offences, bail is a matter of right. It is a right of the accused to be released on bail. It's in bailable offences, again, it's a basic rights of the accused persons to be released on bail. So, when any persons other than a person accused of a non-bailable offence is arrested or detained without warrant by an officer in charge of police stations or appear or brought before a court and is prepared at any time while in the custody of such officer at any stage of the proceeding before such court to give bail, such person shall be released on bail. So in bailable offences, again, it's a statutory right, persons should be given bail. Clause 2. So it was earlier 436 clause 2. Now we have a fourth, this sections 478 clause 2. So 478 clause 2, what it says? Notwithstanding anything contained in subsection 1, subsection 1 talk about the mandatory bail. Even the proviso says that if someone is indigent, he can be released on personal bond, so that you cannot have excessive bail bond, etc. So this says where it says where a person has failed to comply with the condition of bond or bail bond as regard the time and place of attendance, the court may refuse to release him on bail when on a subsequent occasions in the same case he appear before the court or is brought in custody, and any such refusal shall be without prejudice to the power of the court to call upon any person bound by such bond or bail bond to pay the penalty thereof under section 491. So what the circumstances? Suppose someone is arrested in a bailable offences. He produced before the court, court granted him bail of say 1000 rupees with one surety. What is the bail? This is a surety with the direction that he should come to the court. Later on, he did not appear in the court. Then what the court will do? The court will issue warrant, even can go to proclamation, etc. or attachment. Now again, after warrant, he being arrested and brought before the court. Case remain bailable. Clause 2 says now he don't have a right because he already got bail earlier and he has not complied with the condition of the earlier bail. So accordingly, now it is not the right. So this is the only circumstances, even in bailable offences, court may refuse to grant bail. Now another issues which comes is, so clear, everyone understand? So this is the only circumstances when even in bailable offences, a person cannot claim a right to be released on bail. That's the clause 2. Earlier it was 436 clause 2. Now it is under this section. Another issue, Who can grant bail? Remember, court can definitely grant bail. But can police grant bail? Answer is yes, police can also grant bail. When say some inspector is arrested, can he grant bail? He can grant bail. When he proceeds before the inspector, OC, can OC grant bail? Grant bail. So these authority can grant bail. So there is no bar in bailable offences. Anyone, these authorities can also grant bail. Now these are all preliminary bail with direction that he should appear on the court, and the final bail will be given by the court only. So the police also many times they can give bail. That's why you'll find when a person other than a person accused of non-bailable offence arrested and detained without any warrant by an officer in charge of a police stations or brought before a court, so either OC or the court, for both the same mandate, the person shall be released on bail. So the OC can give bail, the court can also give bail. Husne Ara Khatun, we know the case which extensively discuss about the legality issues, rights of the under trial prisoners, and we know in Bihar there are many cases where under trial prisoners were in the jail for far longer time. Then had they been convicted, they could have released earlier. So court they are given many directions, including bail system as prevalent is oppressive. The court comment is very important. So the bail system as prevalent is oppressive and discriminatory against the poor. Courts and the police must abandon the antiquated practice of release only against bond with sureties and permit release on personal bond. Other possible considerations for such pre-trial release pointed out factors for determining accused roots in the community. The court has given circumstances where it can be like bail, etc. Grant or cancellation of bail. This is the High Court judgment. The magistrate has no power to cancel the bail granted in case of bailable offences. Remember when we discussed. Now 479. Now when it's 479, they have added one more thing. And there they added, instead of one half, in case of first time offender. So you will find proviso. Provided that where such person is a first time offender who has never been convicted of any offence in the past, he shall be released on bond by the court if he is undergone, it laid down the criteria, if he is undergone 1/3 of period of the imprisonment if it is there. So say for example, there is a punishment of 3 years. If the person is in jail for a year, that's good enough require him to be released on bail. That's the proviso has been added there. So it was earlier 436 that become 436 capital A, that become 479 in the new act. And this is again we can say is a statutory bail where persons shall be released. The word shall is there, he shall be released on bail by the court on bail. So if the person is there in jail for half of the period, shall be released on bail. If the first time offender 1/3 of the period, shall be released on bail. The subsequent part laid down some exceptional circumstances where if the public prosecutor etc. they oppose or some other circumstances exist, then in those circumstances court may not imply give bail also. So provided that the court may, after hearing the public prosecutor, for the reasons to be recorded in writing, order the continued detention. So instead of releasing, they may give order for continued detention, that also possible. But as a normal rule, the person should be enlarged on bail. One more thing has been added, and that's a really good thing. Clause 3. And the clause 3 mandate that the superintendent of a jail has an obligation that on completion of 1/2 or 1/3 of the period mentioned in subsections 1, as the case may be, shall forthwith make an application in writing to the court to proceed under subsection 1 for the release of such persons on bail. I think it's very excellent provisions. So there is a positive obligations on the jail authority. Now remember, now there is no jail. We call it correctional home. So if it is in real sense a correctional home, this should be the priority work for the jail authorities. That once the period is over of half or one third, application should be filed in the court for the release of the accused persons. That what the clause 3 has been added in the new act. It's a excellent inclusions in the new law. So now what we discussed till now was where the accused has right to be released on bail. Now we come to other circumstances when accused has no right to be released on bail, but it is the discretion of court. When it is primarily in non-bailable offences. So 480, when bail may be taken in case of non-bailable offences. Clause 1, it says, when any person accused of or suspected of the commission of any non-bailable offence. So earlier we discussed about bailable offences, now it is non-bailable offences. So if he is either commission of or suspected of commission of some non-bailable offences, is arrested or detained without warrant by an officer in charge of the police station, or appear or is brought before the court other than the high court or court of session, he may be released on bail. Here is not shall, may. Again the questions come, who may release? Again here also, can officer in charge release? Yes. Can court release? Yes. But there are some restrictions. Number 1, such persons shall not be so released if there appear reasonable grounds for believing that he has been guilty on offence punishable with death or imprisonment for life. So in cases death or life imprisonment, the magistrate should not release on bail. Here in the beginning it says other than High Court and Court of Session, because for High Court and Court of Session, we find another section, we have 482, you will find the High Court and Court of Session power. 2. Such person shall not be so released if such offence is cognizable and he had been previously convicted of an offence punishable with death, imprisonment for life, or imprisonment for 7 years or more, and he had been offence punishable with imprisonment for 3 years or more, but less than 7 years. So if a person is convicted earlier for minor offences where punishment is 3 to 7, if he convicted twice, then he is not entitled to bail. He may not be released on bail, shall not be released on bail. If he convicted for where the punishment is more than 7 years, etc., death penalty, life imprisonment of more than 7 years, then he shall not be released on bail. So these are the restrictions which has been imposed. But then remember, the bail is a discretion of the court, and many occasions even magistrate court do grant bail, provided that, and that is the proviso, provided that the court may direct that a persons referred to in clause 1 or clause 2 be released on bail if such person is a child or is a woman or is sick or infirm. So these are the special conditions for women, for the children, for the sick, for the infirm. That is the word has mentions there. Provided further that the court may also direct that the persons referred to in clause 2 be released on bail if it is satisfied that it is just and proper so to do for any other special reasons. So if there are any other special reasons also, the court can release on bail. What else? There is another, it's not restrictions, it's the rights which is recognized. So this proviso again says, provided also that mere fact and accused persons may be required for being identified by the witness during investigation. Now, normally we call it TI period, test identification period. So, many times in the court when accused is produced, PP put forward Their views that these persons require for TI parade, and accordingly they ask for not to grant bail. Court says that should not be sufficient reason. So, identified by the witness during investigation or for police custody beyond the first 15 days shall not be sufficient ground for refusing to grant bail if he is otherwise entitled to be released on bail, and gives an undertaking that he shall comply with such direction as may be given by the court. So remember, the court can, while granting order, court can give bail. That power the court has. Provided also that no person shall, if the offence alleged to have been committed by him is punishable with death, imprisonment for life, or imprisonment for 7 years or more, be released on bail by the court under this subsection without giving an opportunity being heard. So the other side, victim, prosecutors need to be given opportunity. So these are the provisions on the non-bailable offences of the magistrate power. So these sections talking about 480 non-bailable offences by magistrate, where the magistrates can refuse to give bail. Clause 2 says, if it appear to such officer or court, officer implies here officer in charge, and court implies magistrate court, at any stage of the investigation, inquiry, or trial, as the case may be, that there are not reasonable ground for believing that the accused has committed a non-bailable offence, but that there are sufficient ground for further inquiry into his guilt, the accused shall, subject to the provisions of section 492, and pending such inquiry, be released on bail or at the discretion of such court officer or court on the execution of him of a bond for his appearance as hereinafter provided. So bail can be given. There are other circumstances also when a person accused of suspected of commission of an offence punishable with imprisonment which may extend to 7 years or more of an offence punishable under chapter 6, 7, 17 of BNS, or abatement of a conspiracy of such offences, is released on bail under section 1, the court shall impose conditions. What kind of conditions court can impose? One, that such person shall attain in accordance with the condition of the bond executed under this chapter. Now, conditions can, there are many times when the court impose conditions. For example, that the accused will cooperate with the investigation. Accused will meet with the IO, etc. That such person shall not commit an offence similar to the offence for which he is accused or suspected of the commission of which he is suspected. And C, that such person shall not directly or indirectly make an inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the police officer, or tamper with the evidence, and may also impose in the interest of justice such other condition as it are considered necessary. So that's the basically power where these some leeway which available with the court. In some cases, court can grant bail even in non-bailable offences, which are by the magistrate court. So this section 480 is exclusively it is for the magistrate court. 4 says, an officer of the court releasing any persons on bail under subsection 1 or subsection 2 shall record in writing his or its reason or special reasons or so doing. So now by this clause 4, reading of it make clear that even these kinds of bail can also be granted by officer in charge. It is possible. Very lengthy section. Clause 5 says any court which has released a person on bail under subsection 1 or section 2 may consider necessary do so, direct such persons be arrested and commit. This is cancellation of bail. Now we'll discuss cancellation of bail at the end. So these procedures which are there under these sections, clause 6 talk about if any case triable by magistrate, the trial of a person accused of any non-bailable offence is not concluded within a period of 60 days from the first date fixed for taking evidence in the case, such person shall, if he is in custody during the whole of the said period, be released on bail to the satisfaction of the magistrate, unless for the reasons to be recorded in writing, the magistrate otherwise direct. So this is again a statutory right of the accused to get bail if within 60 days, if the case is not ended, trial evidence is not over, then again the person has a right to get bail in the magistrate tribal cases. 7. If any time after the conclusion of the trial of a person accused of a non-bailable offence and before judgment is delivered, the court is of opinion that there is a reasonable ground for believing that the accused is not guilty of any such offence, it shall release the accused if he is in custody on the execution of him of a bond of his appearance to hear judgment delivered. So the questions in many time arises about the condition of bail or what are the consideration for bail, etc. So this is a case Parvez Nuruddin Lokhandwala versus State. Uh, Supreme Court says relevant consideration for imposition of the condition for bail. Summarize, court laid down what could be the condition, necessity of proportional relationships between the condition which are imposed and the purpose imposing the conditions. So there must be some correlations and some kinds of thing which they want to achieve. Dilip Singh case, a criminal court exercising jurisdiction to grant bail oblique anticipatory bail is not expected to act as a recovery agent for realize the dues of the complainant and that too without any trial. So court has cautions. Now anticipatory bail cannot be done by the magistrate. We will discuss in the next class. Anticipatory bail is either done by the court of sessions or the high court. Now we come to 481, which says bail to require accused to appear before next appellate court. Now, many times happened when the lower court has given punishment, then the accused will file appeal in the appellate court. So, is it necessary to send him jail and file appeal? Answer is no. Court can give bail also. So, before conclusion of a trial and before disposal of the appeal, the court trying the offence or the appellate court as the case may be, shall require the accused to execute a bond or bail bond to appear before the higher court as and when such court issue notice in respect of any appeal or petition filed against the judgment of the respective court, and such bond shall be enforced for 6 months. If such accused fail to appear, the bond stand forfeited. That's what the provision says. This normally happens. Suppose a magistrate court convicted someone for 2 years. Think about Rahul Gandhi case. Now definitely he will file appeal. Does it require to send him to jail? Answer is no. He can be given bail, asking him that to appear in the superior court, and accordingly the superior court can decide, take a call. So there might be circumstances when bail can also be given on personal bond. So if the court is satisfied on a consideration of the relevant factors that the accused has his ties in the community and there is no substantial risk of non-appearance, the accused may, as far as possible, be released on his personal bond. That also possible under the law, depending on his standing in the society, etc. Now we come to, so we discuss about bailable offences, we discuss about bailable offences by magistrate. Now we come to the third categories of bail, which we call anticipatory bail. Now anticipatory bail is also by the court of session or the high court. When we use this word anticipatory bail, remember the word as implies it is not in real sense bail. Why is not real sense bail? What is the bail meaning? Bail meaning release of a person on submission of surety. Now the person is not arrested. So where the question of release comes? So anticipatory bail is not in real bail. Actually, thereby there are cases where court says the word anticipatory bail is a misnomer. It's not the real sense, the true meaning. Because the accused is not arrested, not that in case the accused be released, arrested, he can be released on the bail of such and such amount. So that's the application. Earlier it was 438, now become 482. So direction for grant of bail to the apprehending arrest. So if anyone who is apprehending arrest may apply to the court of session or may apply to the high court for a directions that he can be released on bail as and when he be arrested. So clause 1 says when any person has reasons to believe that he may be arrested on an accusation of having committed a non-bailable offence, he may apply to the High Court or Court of Session for a direction under this section, and the court may, if it thinks fit, direct that in the event of such arrest, he shall be released on bail. Clause 2. When the High Court or Court of Session make a direction under subsection 1, it may include such condition as such direction in the light of the facts and circumstances goes as it thinks fit. So court can issue some conditions. What kind of condition? Which include A1, a condition that the person shall make himself available for interrogations by the police. So he will visit the police station, he will be available for the interrogations. A condition that the person shall not directly or indirectly make any inducement, threat or promise to any persons acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or to the police officer. So he will not threaten any witnesses, he will not induce witnesses, etc., directly or indirectly. 3, a condition that a person shall not leave India without the previous permission of the court. Such other condition as may be imposed under subsection 3 of section 480 as it the bail were granted under that situation. So any other condition which court thinks appropriate, court can pass those kinds of order. So court will pass order, you submit your passport so that you cannot go abroad. Any condition can be imposed. Clause 3 says, if such person is thereafter arrested without a warrant by an officer in charge of a police station on such accusation and is prepared either at the time of the arrest or any time while in the custody of such officer to give bail, he shall be released on bail. Now, this again make clear that even if some anticipatory bail order was given, that does not mean he cannot be arrested. Only thing is, as soon as he will be arrested, he is entitled to get bail as per the order of the court. And accordingly, please don't arrest. There is no point in arresting because from the one hand you arrest him, other hand you have to release him. And if a magistrate taking cognizance of such offence decide that a warrant should be issued in the first instance against such the person, he shall issue a bailable warrant in conformity with the direction of the court under subsection 1. So even when the magistrate issues a warrant, it must be bailable warrant. Clause 4 says nothing in this section shall apply to any case involving the arrest of any person on accusation of committed an offence under section 65 and 70 of BNS. So these sections, if some offences are there, then in those cases anticipatory bail is not applicable. So 65 and 70 both are about the rape and gang rape cases. So the law has restricted the applicability of rape and gang rape cases and applicability of anticipatory bail in rape and gang rape cases. Prithvi Raj Chauhan was Union of India. Court says the right to anticipatory bail can be taken away by statute. There are some statutes which may take away. There are many acts under which the bail may not apply, anticipatory bail may not apply. Object of the condition in anticipatory bail. Now, the reasons for the condition is, there the court says is, while granting anticipatory bail, though the court may impose such condition as it think fit, the court of putting conditions should be to avoid the possibility of the persons hampering investigations. The whole idea is just to avoid any kinds of hamper the investigation. Anticipatory bail conditions to be of a judicial discretion. Remember, this anticipatory bail, these are all, it's not the right, it's a discretion of the court, discretion of the authority which are granting it. So when it is a discretion of the authority which is granting it, how they can exercise this jurisdiction? The court, while exercising jurisdiction under section 438 CRPC, must bear in mind and to be satisfied that the accused will not abscond or otherwise misuse liberty, and this can be ascertained from several factors like conduct of the accused in the past, his asset in the country, and so on. But while granting such anticipatory bail, though the court may impose such condition as it think fit, but the object of putting conditions should be to avoid the possibility of the person hampering investigation. The discretion of the court while putting conditions should be an exercise of judicial discretion. So that's what the court says. Now, in anticipatory bail, factors for consideration after charge sheet is filed to be considered. It says the gravity of the offense and also the need for custodial interrogations are the factors. The gravity of the offense is an important factor to be taken into consideration while granting anticipatory bail. The Court of Session, High Court or Supreme Court have the necessary power vested in them to grant anticipatory bail in non-bailable offences. Even when cognizance is taken or a charge sheet is filed, provided the fact of the case required to do so. So, Bharat Chaudhary, it says the court can grant at different stage. Now, remember one of the issues which cropped up earlier, which court had discussed in Salahuddin Abdul Samad Sheikh case, 1996. Suppose the court is granted anticipatory bail, is it absolute for unlimited period of time? Answer is no. It for limited period. Accordingly, when you look at any anticipatory bail order, it all invariably specifies some timeline within which the person need to go to the local court and get regular bail. So this is only for the anticipatory bail. This Supreme Court says it should be realized that an order of anticipatory bail could even be obtained in cases of serious nature, as for example, murder, and therefore it is essential that the duration of that order should be limited, and ordinarily the court granting anticipatory bail should not substitute itself for the original court which is expected to deal with the offence. It is that court which has then to consider whether, having regard to the material placed before it, accused person is entitled to bail. So it's normally a period in which the person is given right to get bail from the local court or lower court. The above ratio decision has been followed in subsequently in KL Verma vs. State 1998 judgment. It was further clarified that the limited duration must be determined having regard to the facts of the case and the need to give the accused sufficient time to move the regular court for bail and to give the regular court sufficient time to determine the bail application. In other words, till the bail application is disposed of one way or other, the court may allow the accused to remain on anticipatory bail. To put it differently, the anticipatory bail may be granted for a duration which may extend to the date on which the bail application is disposed of, or even a few days thereafter, to enable the accused persons to move the higher court if they so desire. Important case, famous Hema Mishra vs. State of UP. And court say there is no effect of order of anticipatory bail on police power to investigate, etc. So basically, even if the court has granted anticipatory bail, it does not restrict court power. The investigations can continue. So police can continue with the investigations even when there is an anticipatory bail is granted. Gurbakh Singh Sibia case, 1980, very old case, but it's extensively discussed on the anticipatory bail. And there the court says, meaning of reasons to believe explained by the court, application for invoking the section event, and should not be vague. Court should not issue blanket order, which I said is not for unlimited time. It must be specified time. It should not be that he cannot be arrested in any case. It should be in respect of any particular case, specific FIR. So if a person says I am apprehending arrest in X FIR, court can discuss only on that context. It does not mean he cannot be arrested in Y case or Z case. So an event and should not be vague. Court should not issue blanket order and should apply its own mind. It can be invoked prior to arrest. FIR need not be filed before it is invoked. A previous notice to the public prosecutor is was necessary earlier. General principle with regard to anticipatory bail has been discussed very detailed in the Gurupal Singh case. This is another case called Sitaram Satingappa Metre, State of Maharashtra. And court suggested 6 suggestions they have given, albeit illustrative ones and not exhaustive, given which might dispense with the necessity to curtail personal liberty of the accused. So why we should curtail the personal liberty and not grant anticipatory bail? Rana Jalal was State of Kerala, anticipatory bail in triple talaq cases. Court says anticipatory bail can be granted to a person apprehending arrest under Muslim Women Act 2019, subject to conditions that competent court must hear married Muslim women upon whom the triple talaq is pronounced, and all the requirements specified in 7C of the Act are satisfied. Section 430 CRPC is not superseded by Section 7C of that Act, and the manner of operations of non-obstacle clause under that section the court extensively discussed. That means the persons can approach for anticipatory bail. This is another case called Mehtab Alam versus State of Bihar. So posting of anticipatory bail cases, it is the duty of the registry of the court to post such cases with due diligence. Remember, in some places, anticipatory bail, etc., take long time. I am told in Bihar and some places, when you file anticipatory bail list, it comes in the list after a long time. So it should be on the fast basis. So now anticipatory bail is over. Now we come to the last part of the bail. Bail by session court and high court. Extraordinary power which they have. So 483 says a high court or court of session may direct that any person accused of an offense and in custody be released on bail. Okay. This extraordinary power which exercised by the high court or court of session. So it is a concurrent jurisdictions. Either the court can take jurisdiction depending on the application. So 483 is an extraordinary power, and it says a high court or court of session may direct A, that any person accused of an offense and in custody be released on bail, and if the offense is of the nature specified in subsection 3 of 480, may impose any condition which is considered necessary for the purpose of mentioned in subsection. So the court of session and high court has been given very wide power here under 483. B, that the conditions means which are being mentioned imposed by a magistrate when releasing any persons on bail be set aside or modified. So court can, whatever the magistrate has imposed, it can be set aside, it can be modified. Provided that high court or the court of session shall, before granting the bail of the person who is an accused of the offence which is punishable, triable exclusively by the court of sessions, and is punishable with imprisonment for life, give notice of the application of bail to the public prosecutor unless it is for the reasons to be recorded in writing of opinion that is not practicable to give such notice. So law mandate that in these serious cases, notice need to be given to the public prosecutor. Last proviso says, provided further that the High Court or the Court of Session shall, before granting bail to a person who is accused of an offence triable under 65 and 70 of the BNS, rape and gang rape cases, give notice of the application of our bail to the public prosecutor within a period of 15 days from the date of receipt of the notice of such application. Remember, no mention of the victim directly here. We'll discuss when we discuss about the victims. Now, clause 2. The presence of the informant or any other authorized person shall be obligatory. Clause 3. Clause 3 was earlier clause 2 later. So, what are the ways in which the bail can be granted, etc.? So, State of Bihar versus Raj Ballabh Prasad. So, court summarized the principles related to relevant consideration for granting bail, and those are basically different circumstances, gravity, accused presence, accused standing, everything they take into account. Manoj Kumar Khokhar, grant of bail without considering relevant aspects and recording reasons is not justified. The law being summarized regarding the principle of a grant of bail, therefore. There is another case, Najib, K. Najib, Union of India versus K. Najib. Presence of a statutory restrictions provided for under provisions like 430, 4030, 43D, 5 of UAPA per se does not oust the ability of the Constitutional Court to grant bail or ground of violations of Part 3 of the Constitution, which cover within its protective ambit not only the due procedure and fairness but also access to justice and a speedy trial. So, it's basically court talk about the power of the court that even in these kinds of cases of the court can grant bail. Satinder Kumar Antil, CVI, direction issued to investigation agencies and to the court for proper exercise of the power while granting anticipatory bail. Those such directions to be read subject to state amendment. Offences have been categorized and the guidelines therefore based on categorization of the offences have been issued by for the grant of bail but without fettering the discretion of the court concerned and keeping in mind the statutory provision. That means the court has the right to be released on bail. Now, there is a very interesting case story, P. Chidambaram versus CBI. Basically, P. Chidambaram was by the ED, he was brought in, charge against him, etc. So, about his bail, there was the issues, and Supreme Court has discussed extensively about the apprehension of flight. That means person may run away, etc. That could be one of the consideration. So, given reasons for exercise of discretion in granting or refusing to grant bail is mandatory, but it is different from discussing merit or demerit of the case. Discretion of court has to be exercised judiciously and not in arbitrary manner. That is the mandate of the court. There is another case called Brij Mani Devi versus Pappu Kumar. And court says the principles the court clarified relating to necessity of recording of the regions and extent to which regions are required in bail order. Giraj versus Kiran Pal. Cancellation of bail. Now we'll discuss cancellation of bail little later, but let as the PPT is here, let we see. So it says when bail has been granted to the accused on the basis of parity with the bail granted of the co-accused, subsequent cancellation of bail granted to the co-accused must have been similar consequence insofar as the grant of bail to the accused is concerned. So if the other bail you are cancelling, you must cancel the co-accused bail also. Ramesh Bhavan Rathod versus Vishan Bhai Hira Bhai Makwana. Bail on the ground of parity with co-accused. So while applying principle of parity, court cannot exercise its power in a capricious manner and has to consider totality of the circumstances before granting bail. In deciding aspect of parity, the accused, their position in relation to the incident and to victim is of utmost importance. Lakshman Das, foreign citizen, no special consideration can be given to accused in granting bail simply because he's a foreigner. So, same consideration. Hussain versus Union of India, speedy conclusion of criminal trial and appeal. So, in view of that action already have been issued by the Supreme Court in a number of cases on this issue, High Court must frame guidelines and take a step to effectuate those directions. Hence, hence all High Court to frame annual action plan fixing. So that's basically process for granting bail. Now, remaining sections of this chapter were all procedural in nature. We don't need to devote much time on it. So, like 484 says, the amount of bond and reduction thereof. The amount of the every bond executed on this chapter shall be fixed with due regard to the circumstance of the case. So, it's not that it should not be exorbitant. High Court of Court may direct that the bail requirement by a police officers or magistrate be reduced. Bond of accused and surety. Before any person is released on bond or bail bond, a bond of such sum of the money as police officer or the court, as the case may be, thinks sufficient, shall be executed. So that's the basic process. 486, declaration by sureties. So those who are standing as a guarantor or sureties, they should also give a declaration. So every person is standing surety to an accused person for his release on bail shall make a declaration before the court as to the number of the persons to whom he has stood surety, including the accused, giving their in all the relevant particulars. Now, this was added in the CRPC at much later stage, uh, only for the purpose of to the consider that many time it is found that the same person is become surety for many other persons. So you'll find maybe few, you'll find that few of the advocate clerk who become surety are the surety of thousands and thousands of cases. So to check some kinds of stoppage of abuse, etc., the law has laid down in that way that now when the accused person is really bail is being granted in those cases, the bail bond must mention how many persons is a grantor or how many persons is a surety, because that will give idea to the court whether the persons whom they stand as a bail guarantor are really we can consider as a fit persons for the purpose of this bond or not. So that's one of the issue which which the court discussed in many times. 487, discharge from the custody. As soon as a bond or bail bond has been executed, the persons for whose the appearance has been taken, they shall be released on bond, bail or discharge. Power of the order, sufficient bail when that first taken is insufficient. So if the first taken was insufficient, they can order again for further bail amount under 488. 489, discharge of the sureties. All or any sureties for attendance and appearance of the persons released on bail may at any time apply to a magistrate to discharge the bond either wholly or so far as relate to the accused. So maybe tomorrow that surety may come to the court and say, I don't want to be his surety. Then court will pass order for some other surety under this section 489. Though in practice this rarely happened. Now this is very important section 490 and very interesting section also. In the old law, it was 445. So let me read it and then I'll discuss one or two cases on it. 490 says, when any person is required by any court or officers to execute a bond. So suppose someone is being arrested, brought before the court, and he is asked to give the bond of rupees, say 1 lakh with two sureties. He might not able to get two sureties. Under 490, it permit that person may file an application under this section that, okay, instead of surety, he is ready to give recognizance. That means he can submit the amount to the court. So it says that when any person required by a court or officer to execute a bond or bail bond, such court or officer may, except in cases of a bond for good behavior, permit him to deposit a sum of money or government promissory notes to such amount as the court or officer may fix in lieu of executing such bond. So instead of that bond, the persons can deposit cash. So that's a provision which is there in the, it was there in the CRPC, the same thing has been added in the BNSS. So that's a very important issue came in quite a few cases, like in Sasikala versus Directorate of Enforcement. And the Supreme Court says the section 445 does not empower the magistrate to demand a cash security, but may permit accused persons to deposit a sum of money in lieu of executing a personal bond or giving surety of some person. So, court clarifies that this is the possibility. But it's a very interesting case which happened, and you will find, you can search Google, you will find this case. Charles Sovraj, we all know, we heard this name of Charles Sovraj, the criminal which was wanted in many countries in the world, and he was in Tihar jail. So, in one of the case, he was asked to give personal bond, furnishing a personal bond in sum of rupees 50,000 with two sureties in like amount. So the two sureties will come and give the bond of 50,000, 50,000 each for the purpose of his release. That's the order by the court. Now the Charles Sovraj says that I am foreign national, I am not getting anyone who stand my guarantor. Accordingly, he is not released from the custody. So he praised to the court that the trial is likely to consume a few more years, and he is a foreigner with nobody known to him in Delhi. He may be permitted to deposit a cash surety of rupees 25,000 in lieu of a surety of 50,000 rupees. So he says he will be allowed to give cash deposit. A very interesting judgment to read. The court says that the purpose of surety is not only to get money. The purpose of surety is to make sure that someone stands as a guarantor who is taking guarantee to bring the offender before the court. That's the ultimate idea. So the money cannot replace it. Accordingly, this requirement cannot be fulfilled by the money, by the amount. So court did not approve. So no ground to exercise discretions. Court says my discretions for these cases. Discussion in favor of the petitioner. The petitioner is accordingly, it was disposed of. So court did not approve it. Now the some sections of this chapter talking about, in some cases, bond can be forfeited under 491. So where a bond under the Sanhita is for appearance or production of property before a court, and it is provided proof to the satisfaction of a court or any court to which the case has subsequently been transferred, that bond has been forfeited. On respect of any other bond under Sanhita is proves the satisfaction of the court by which the bond was taken, or any court to which the case has been subsequently been transferred, or of the court of any magistrate of first class that the bond has been forfeited, the court shall record the ground of such proof and may call upon any person's bond by such bond to pay the penalty thereof and to show cause why he should not pay it. So that's a different procedure in which that money can be recovered, 491 onwards. And there's a process which are there. Now we rarely have this. 492 says cancellation of bond and bail bond. So this section permits, so without prejudice to the provision of 491, where a bond or bail bond under the Sanhita is for appearance of a person in a case and it is forfeited for the breach of conditions, the bond executed by such person as well as the bond, if any, executed by one or more of his sureties, in that case shall stand cancelled. So the person does not appear, etc., then bond can be cancelled under 492. You can read yourself the entire provisions. 493 says procedure in cases of insolvency or death of the surety or when a bond is forfeited. So again, we require some subsequent bond, etc. Bond required from the child. When the person required by any court or officers to execute a bond is a child, such court or officer may accept in lieu thereof a bond executed by a surety or sureties only. Appeal from order under section 491. So all order passed under 491 shall be appealable. Now it does not require for us. For the court direct levy of the amount due of certain recognizance, we don't require. Now we come to the last topic, and the last topic is cancellation of bail. Remember, the cancellation of bail we have seen in two places. One, we have seen when there was a provisions for bail in non-bailable offences by magistrate, the clause 5 was there. Another, we have seen where the provision was bail by the Court of Session and High Court. There clause 3, earlier was clause 2, now clause 3. The cancellation provision is there. So first provision, 480 clause 5. So 480 was in respect of bail in non-bailable offences by magistrate. So the magistrate who grant bail, so clause 5 says any court which has the release of persons on bail under subsection 1 or subsection 2 may, if it consider it necessary so to do, direct that such person be arrested and commit him to custody. That means cancellation of bail. So the magistrate which granted bail under clause 1 or clause 2 of 480 can cancel the bail under clause 5 of section 480. That is permissible. Same way, 483. Now, 483 says about the High Court and Session Court power. So, clause 1 is about the bail provisions. Now, here you will find a High Court or Court of Session may direct that any person who has been released on bail under this chapter. Now, here it does not say that by that court. This chapter. That means even if the bail is granted by the magistrate, the court, High Court or Court of Session has power to cancel under clause 3 of 483. So a High Court or Court of Session may direct that any person who has been released on bail under this chapter be arrested and commit him to custody. So the bail can be cancelled by the High Court or Court of Session under section 483 clause 3. Now, very important power. So court granted bail and the bail is being cancelled. When court should exercise this power? Remember, granting bail is one consideration, but cancellation of bail is another consideration. Unless these are very serious issues of violating the bond provisions or misusing the liberty, court is not inclined to give cancel the bail, because the cancellation of bail require much higher evidence to show that there is a jeopardies which the person has suffering because of this grant of bail. So these two sections are there. One, magistrate can cancel bail of all the bail which they have granted under 480. Under 483, the Court of Session and High Court can cancel any bail granted under this chapter. That means even if the bail is granted by the magistrate, that can be cancelled by this Court of Session and High Court. Even if the court has granted bail, that can be cancelled by Court of Session or High Court. So the cancellation of bail is having a very serious consequences, and accordingly we require to use only in the limited circumstances. So this is the case Mehboob Daud Sheikh versus State of Maharashtra. Supreme Court says bail should be cancelled in cases where the person tries to interfere with the course of justice or attempt to tamper with evidence or witnesses or threatens witnesses or indulges in similar activities which would hamper smooth investigation or trial. So if it adversely impact the investigation or trial, then it can be cancelled. Rejection of bail stands on one footing. Remember, very important comment. Rejection of bail stands on one footing, but cancellation of bail is harsh order. Well, once you given liberty, you cannot curtail. That's the basic principle. Once you granted liberty, now it is unfair to curtail without some justification which are too strong. So rejection of bail stand on one footing, but the cancellation of the bail is a harsh order because it take away the liberty of an individual granted and is not lightly resorted to. So we should not, as a matter of fact, when circumstances. So what are the general grounds of cancellation of bail? So in Aslam Babalal Desai, state of Maharashtra, Supreme Court given some of the indicators. Now, these are not hard and fast rule, but some of the indicators which may help to understand the court in cancellation of bail. So the ground for cancellation of bail, which may be order under 437(1) or 439(2), what are there? Misuse of liberty by accused person by indulging in similar criminal activities. Again, he started committing same crime. Interference with the course of investigation. It's a hamper investigation. Attempt to tamper with evidence of witnesses. Threatening witnesses or indulging in similar activities which would hamper a smooth investigation. Likelihood of fleeing away of the accused to another country. So apprehension of flight, he may run away. Attempt to make the accused scarce by going underground or becoming non-available to investigating agencies. So he may be asked, might to appear with the police or cooperate with the investigation, but he's becoming underground. Attempt to place himself beyond the reach of his surety. So these are the illustrative and not exhaustive list. So these are just indicator on this ground. If the court thinks appropriate, the bail which has been granted can also be cancelled. So this is basically bail grant is on one footing, cancellation in other. For cancellation, we require much larger evidences, etc. Then only bail can be cancelled. But yes, bail can be cancelled under this clause. Bail cancellation on the allegation threat of the witnesses. So, Supreme Court in Raghuveer Singh versus State of Bihar, court says the ground for cancellation under 437(5), 432 are identical, namely bail granted under that, etc. If accused misuses liberty, indulging civil activity, interfere with the court investigation, attempt to tamper with evidence, threatening witnesses, likelihood of fleeing. So all these which we discussed, these grounds are illustrative. When a person to whom bail has been granted either tries to interfere with, etc., though in those circumstances also bail can be cancelled. For cancellation of bail, aggrieved party can also move locus standi. Who can cancel the bail? Now, very interesting case happened. Here you will find the second case, R. Ratinam versus State. In Punjab and Haryana court has granted bail to some person. Now, entire bar association was annoyed and 75 advocate has filed application for cancellation of bail. High Court cancelled bail. Then the matter was went to Supreme Court. So issue was whether this advocate who filed an application in R. Rathinam case, whether they have a locus standi. The Supreme Court says, if there is an unwanted bail, then who will be sufferer? Entire society. So the Supreme Court says when there is unwanted bail, the whole society becomes sufferer. Every single member of the society has a right to file application for cancellation of bail. They have locus standi. So R. Rathinam case has it has increased the ambit of the issue of locus standi when we file application for cancellation of bail. So in Puran versus Rambilal court says there is nothing to indicate that the power exercised under 439(2) can be exercised only if the state or investigating agencies or public prosecutor moves a petition. It is held that power so vested in the High Court can be invoked either by the state or by the aggrieved party. It was held that the said power could be exercised suo motu by the High Court. It was held, therefore, that any member of the public, whether he belonged to a particular profession or otherwise, could move the High Court as to remind it of the need to exercise its power suo motu. So, court can do suo motu also. Case, little old case, 1978. You must have heard this person name, Sanjay Gandhi. So let me briefly just explain what happened was. So that point of time, some filmmaker made a film. Film name was Kissa Kursi Ka. So this film basically depicting probably Indira Gandhi's and um, emergencies, etc. All those were the issues. So the Sanjay Gandhi was Youth Congress leader at that point of time, and they said that we will not allow this film to be shown in Delhi. Now we see in many places similar agitation people's raise, and what we'll see in cinema, some throwing a stone, hurting, etc. All those things happen. So when this reel etc. in the old days, it was all the real big size reels were there. So they took those reel, went to the Maruti factory, they burned the reel there. So case was started against Sanjay Gandhi, and there's an allegation that he was threatening some witnesses. And accordingly, there was a prayer was filed by CBI or some other Delhi police for cancellation of bail. So very interesting thing to read on cancellation of bail, and uh, where so court has discussed extensively about the cancellation of bail. So court says that if there is a threatening to witnesses, if there is a hampering in trial, if the witness will apprehensive of coming to the court, etc. In those circumstances, bail can be cancelled. So court cancelled the bail in this case of the Sanjay Gandhi. So the bail was cancelled there. There is a recent case, Gudiya Swayam Sevi Sansthan versus State of UP. Many times when we read judgment, we try to guess from first para, second para, what is court is going to read. Many times we just read head note. We don't need the whole judgment. It is very risky. Because many cases, when we read whole note, like head note, or even whole judgment except last para, we will get one kind of impressions. But when you read last para, there is another kind of impressions. So this was a case, very serious case, where some trafficking accused, the trafficking victims who trafficked the girls, their bail was granted by the court. And the challenge was made by the Gudiya, as a NGO, for cancellation of bail. Now, there when you read the Supreme Court judgment, when you read this judgment, you will find from throughout paragraph, you will find this trafficking is a heinous crime, it's the worst kinds of crimes, this kinds of accused does not deserve bail, etc. So, your impression will be the court is going to cancel the bail. That impression you will get. But the last paragraph says, we, however, keeping in view the peculiar facts and circumstances of this case, are of the opinion that as the private respondent have been granted bail long time back, and in some cases the trial have also been concluded, it would not be proper on our part to cancel the bail at this stage. We, however, would place on record that in a case of this nature, the High Court should have dealt the matter cautiously. The appeal is dismissed with aforesaid observation. So many times the last class say we are not cancelling the bail. This case deserved not to be granted bail. Had it come earlier, it could have been cancelled bail. But now at this juncture, we are not going to cancel bail. And that's why many times when we read the whole judgment, we get one kind of impression. When we read the last paragraph, we get the another kinds of impressions. That's happened on many occasions. Okay, that's the part on the cancellation of bail. And I said earlier also, the grant of bail is on one footing, but cancellation of bail is another footing. Cancellation of bail, much larger consideration is required, because when you cancel someone's bail, you are taking away their liberty. When you are taking away their liberty, you must be cautioned that there is an apprehension of destruction of evidences, it will hamper in the trial, etc. So only on those circumstances, when you have a very cogent, clear reasons for cancelling, then only court can cancel. So even cases like trafficking cases, Gudiya case, Supreme Court did not cancel the bail. in those circumstances. Okay, that's it from my side.